This meeting to order. Welcome to meeting number 54 of the House of Commons Standing Committee on Citizenship and Immigration. Today we will be commencing our study on the Bill S-245, an act to amend the Citizenship Act, granting citizenship to certain Canadians. Pursuant to the order of reference of Thursday, June 23, 2022, the committee will commence consideration of Bill S-245, an act to amend the Citizenship Act, granting citizenship to certain Canadians. On behalf of the committee, I would like to welcome officials from Immigration, Refugees and Citizenship Canada to provide opening remarks. Today, we are joined by Nicole Gerard, Director General Citizenship Policy, Ewan Huang, Senior Director Legislation and Program Policy, and Elaine Laurentiel, Senior Counsel Legal Services. Before we go into the opening remarks, just a reminder that all amendments to the bill must be submitted to the clerk by Friday, March 31st, 2023 at noon. So that's the deadline for submitting any amendments to the bill S-245. Mr. Brunel de Sepp.
Oui, bon après-midi.
Yes, good afternoon, Madam Chair, and good afternoon to all. Before we begin, Chair, something took place last week. A meeting that was cancelled. A meeting to be held with a German delegation. I would like us to be able to discuss this because there are a number of matters. I'd like some answers to some of my own questions about what took place last week. And perhaps you might prefer carrying out this discussion in camera. This might be sensitive material, and some may prefer not to discuss this in public. But I feel it's incumbent to underscore what took place last week and our need to discuss it in committee.
Thank you, Madam Chair. Just maybe throw out there, if we do want to discuss this and we need to go in camera, that maybe should happen at the end of the meeting, because I know it's a bit of a hassle to switch over to in camera. So just my thoughts on that.
Je suis vraiment d'accord.
I'm fully in agreement with my colleague, Mr. Redekop. I think that we have here before us an important topic. It's a bill that we wish to address. So if we can all agree and if my good colleagues can agree on this, and it is their wish, we could move an in-camera meeting to the end. It takes a few minutes to switch over technically.
The consensus is that we can discuss that issue at the end of the meeting, so we will keep like about 5 minutes to go into that discussion. With that, we would welcome our witnesses for today. You will have 5 minutes for your opening remarks, and then we will go into round of questioning. So time is yours, and you can please, floor is yours, you can please begin.
Thank you, Madam Chair. Is the sound okay? Thank you very much. Before I begin, I'd like to acknowledge that I work on the traditional unceded...
Sorry for interrupting. It's a technical briefing, so I know you requested, so it will be 10 minutes for your opening remarks, and then we will go into round of questioning. Thank you. Sorry for that.
Thank you very much, Madam Chair. Members, good afternoon. Before I begin, I'd like to acknowledge that I work on the traditional unceded territory of the Algonquin and Anishinaabeg people. We are pleased to be here today to support the committee's work on Bill S-245, which seeks to address remaining lost Canadians. While the bill is well intended, as drafted, the bill would not address all remaining lost Canadians and would have some unintended consequences if passed in its current form. Before outlining these concerns, I'll provide a brief overview of the bill and then touch on lost Canadians, past legislative amendments, and the first-generation limit, as these are relevant to the committee's consideration today. In terms of a description of the bill, Bill S-245 is seeking to address remaining lost Canadians by doing three things. First of all, it would amend the Citizenship Act to automatically confer citizenship on some persons born abroad in the second or subsequent generation who lost their Canadian citizenship because they did not take required steps to retain it under the former Section 8 of the Citizenship Act. Secondly, the bill also amends the citizenship legislation regarding automatic citizenship for those born abroad to a Canadian parent and seems to attempt to delay the implementation of the first generation limit to automatic citizenship by descent by moving the date from April 17, 2009 and pushing it out to June 11, 2015. Lastly, for those who would automatically become citizens as a result of the bill as drafted, but who may not wish to become citizens, the bill would allow for regulatory amendments to extend access to what's called a simplified renunciation process to renounce or give up Canadian citizenship. Before touching on the specific issues with regard to Bill S-245, which I will come to in a moment, I will briefly summarize the former provisions of the Citizenship Act that led us to the emergence of lost Canadians, which the committee will be discussing in further detail today. As I am sure you are aware, the requirements and some of the complexities of the first Canadian Citizenship Act of 1947 and former provisions of the current Citizenship Act created cohorts or groups of individuals who lost or never had Canadian citizenship status. These individuals are known to us as lost Canadians. Changes to citizenship legislation that came into effect on April 17, 2009 and June 11, 2015 restored status or gave extended citizenship for the first time to the majority of lost Canadians up to the first generation born abroad to a Canadian parent. Before the 2009 amendments, persons born abroad in the second or subsequent generation to a Canadian parent were considered Canadian citizens from birth, but only until they turned 28 years old, unless they met certain conditions to comply with the former Section 8 retention of citizenship provisions. The conditions for those impacted included a requirement to have lived in Canada for 1 year before submitting an application to retain their citizenship or having established a substantial connection to Canada. If they did not meet the conditions and apply to retain their citizenship before they reached their 28th birthday, they would automatically lose their citizenship. Some were not even aware that they had to meet these requirements and lost their citizenship unknowingly. These Section 8 retention requirements were repealed as part of the amendments to the citizenship legislation in 2009. The 2009 amendments also established a clear first-generation limit to the right to automatic citizenship by descent. This means that today, any child born outside Canada to a Canadian parent is automatically a Canadian citizen from birth if they have a parent who was either born in Canada or who came to Canada as an immigrant and subsequently became a Canadian citizen. That child does not need to do anything to keep their Canadian citizenship. However, those born in the second or subsequent generation abroad do not acquire automatic Canadian citizenship from birth, as the committee is aware. Instead, those born abroad to a Canadian in the second or subsequent generation have to apply for a grant of citizenship. The first generation now makes clear who does not have a claim to automatic citizenship by descent and who needs to instead apply for a grant of citizenship versus those who've obtained it automatically. On the impacts of the bill, Bill S-245 is drafted. As mentioned, the past provisions of the Citizenship Act led to the emergence of lost Canadians. There is a risk, Madam Chair, that passing S-245 as is will have unintended consequences. As drafted, the bill would have at least 3 unintended consequences of concern, as it would firstly create new distinctions as it only remedies some of the lost Canadians who lost their citizenship due to the former Section 8. Secondly, the bill as drafted would create more lost Canadians. And thirdly, it would automatically give citizenship to some for whom dual citizenship may be problematic for legal, professional, or other reasons. The issues with the bill are such that they would have negative impacts for lost Canadians and other Canadians if not addressed through consideration of remedies in the form of amendments to the bill at the committee stage. First, Bill S-245 aims to restore citizenship to persons who lost it as a result of the former Section 8 retention provisions. However, the bill as drafted does not restore citizenship to all those lost Canadians, since it only restores citizenship as drafted to those who never applied to retain it. The bill excludes those who took steps to retain their citizenship by making an application, but were unsuccessful. This would create a distinction by not addressing all of those affected by the former retention provisions and not fully addressing these lost Canadians. Secondly, the bill as written is unclear as to the effect on the first-generation limit, but could be interpreted as moving the limit for anyone born between 2009, April, and June 2015. Moving the date for the first-generation limit from 2009 to 2015 would have a significant impact on untold numbers of persons born abroad in the second generation or beyond who would automatically acquire Canadian citizenship by descent from birth. Though well-intentioned, this is problematic, as some would be negatively impacted and not everyone would benefit. Specifically, those born abroad to a Canadian who have obtained a grant since 2009 would automatically become citizens by descent under the bill, meaning that they would become the first generation born abroad and thereby lose their ability to pass on citizenship by descent to their own children if born abroad, which would create more lost Canadians. In other words, these children who are not yet born would lose access to automatic citizenship because of the shifting of the first generation limit under the bill as drafted. And the bill would still exclude anyone born outside Canada beyond the first generation after June 11, 2015 from citizenship by descent. As such, the bill is giving citizenship or seeks to give citizenship to some persons born abroad in the second or subsequent generation, but not to others, which is a concern and would create more distinctions. Thirdly, in addition to these issues, some persons who become citizens automatically under the bill may find this problematic for legal, professional, or other reasons, depending on the country where they live or work or other circumstances. The bill does provide for a regulation-making authority to allow for simplified renunciation in such cases where folks are born under the former Section 8. However, regulations take time, and the bill lacks necessary provisions to allow for the time to address implementation issues such as this one, which is important to mitigate impacts and concerns. Finally, Madam Chair, Bill S245 is well-intentioned and can be supported, but with several amendments that would be needed to remedy these issues with the bill as drafted. Amendments would be necessary to ensure the bill better meets its intended objectives, to ensure more equal treatment of similar cohorts affected by the former Section 8 retention rules, to minimize the introduction of new distinctions, and mitigate the risk of unintended consequences, such as creating more lost Canadians. With this, Madam Chair, I conclude my remarks, and we would be pleased to address any questions that the committee members may have. Merci.
Thanks a lot. We will now go to our round of questioning, and our first round will be started by Mr. Kimmich. Mr. Kimmich, you will have 6 minutes. You can please begin.
Thank you, Chair. So I was going to go on those three unintended consequences group. You said only remedies some lost Canadians, would create new lost Canadians, and wouldn't restore it, to some persons who were applied to, but they were rejected. So that third group, for those people who applied and then were rejected in retaining their citizenship, what were the reasons for rejecting? Because you're basically implying that we should expand the bill to include them, but if they were rejected then, what was the reason for those rejections?
Thank you for your question. You are correct. The bill is excluding those who applied and who were rejected. We don't have any way to know what the reason for the rejection was, but the concern is that the bill is having a differential impact in addressing some of these lost Canadians and not others. And those who applied had to demonstrate a connection to Canada, whereas the bill is automatically remedying others who never applied and who may have a limited connection, but nevertheless lost their citizenship automatically.
Okay, can I just ask, you're the department, and don't you keep files of those persons that you reject who applied at some previous point, or have those files been lost since then?
Am I on?
You're on.
The department does maintain information. Those who were impacted by the retention provisions are those who were born abroad in the second generation since 1977. And so we may not necessarily have access to files going back that far in time in order to be able to access the reasons why not all of those cases were accepted at the time.
I want to ask you two more questions. I want to make sure I get them all in. You talked about a substantive connection to Canada. How's that determined?
In most cases, applicants who were applying to retain their citizenship had to demonstrate that they were resident in Canada for 1 year. And so that would have been the connection.
365 days continuous?
That's correct.
At any point?
That's correct.
And that was the only connection you had to demonstrate, that you were in Canada for 365 days? Was it based on an attestation, or was it based on actual, like, utilities bills and things like that?
The department at the time would have had procedures in place in terms of various kinds of evidence that could be accepted to demonstrate residence. And to my knowledge, it likely would have included the kinds of proof that you have mentioned.
Well, I'm asking what the proof is. Like, would you take an attestation today, or will you actually require a person to show you utility bills from like 25 years ago?
Madam Chair, the requirements were repealed in 2009, so I can't really speak to what would be required today.
Okay. During your presentation, you talked about the narrowness of the bill perhaps creating these unintended consequences. You used the word problematic as well. Why is it problematic? The narrowness of the bill is part of the reason I think it cleared the Senate so quickly to us. And I think part of the reasons we're all debating it today as well, Madam Chair, is that it's the narrowness of the bill has allowed the bill to sail through, because most people recognize that there's a small group of lost Canadians who are impacted, and that this would be a legislative way to fix an administrative problem that Parliament created after it repeatedly keeps changing the Citizenship Act. So why is it problematic?
The intent of the bill to remedy lost Canadians is one that the department or the government agrees with and can support. The issue is, as mentioned, that some who lost their citizenship automatically as a result of Section 8 are included in the bill and some others are not. And so to avoid creating distinctions, the bill could be considered for amendment at committee stage to cover all of those cases in the narrow cohort.
So in the narrow cohort being the 1977 group?
That's correct. Those impacted by the former retention provisions.
So anyone beyond that, you would say it's not problematic to have those persons excluded. It would only be for the small cohort that this bill is trying to address?
There is a second clause in the bill that's seeking to move the first generation limit for those born abroad in the first generation. And again, there are concerns with that provision in the bill because it's addressing only those born between 2009 and 2015. It's not addressing those born beyond June 2015. And members of the committee, we've noted, have expressed concern about the lack of a mechanism to address those. And that's also a concern that we have noted in submissions from stakeholders who've made representation to this committee.
Right, but the narrowness of the bill, like I said, is part of the reason I think we're here, because that's what I think a lot of parliamentarians like, is shorter bills that are easier to understand. I recognize this is not an easy piece of legislation because every time Parliament has tried to amend the bill, it's usually fallen short. We create new lost Canadians. If the bill sails through in the form it is right now, because you said there would be new lost Canadians created, what's the estimate?
Madam Chair, I don't think we're in a position to estimate how many untold number of Canadians who were born abroad since 2009 could be in the future become lost Canadians as a result of the bill as drafted. But it is a concern that could be addressed during the by amendments in the committee stage.
So it's just a possibility. There's no data that the department holds, having done a review of the bill, and just a projection of possible lost Canadians who might apply in the future, or come to parliamentarians asking them to change the law again to cover them. There's no data.
I think what I'm saying is that the bill as drafted would convert some persons who are granted citizenship since 2009 to become automatic citizens by operation of law under the bill as drafted. And this would remove their ability to pass on citizenship to their children who may be born abroad in future. thereby creating more lost Canadians. So that is a definite scenario, but how many could be impacted in terms of untold numbers in the future, that's not something we're able to estimate at this time, Madam Chair.
We will, time is up for Mr. Kimmich. Now we will proceed to Ms. Kayabaga. Ms. Kayabaga, you will have 6 minutes. You can please begin.
Thank you, Madam Chair. I want to start by thanking our officials for taking the time to come and answer questions on this really important bill. I'm going to go on questions around the section number 8 because it's a very complex issue, and I want to make sure that we can all leave this room understanding exactly what we're talking about and which lost Canadians this bill is going to provide a remedy for. And in your presentation earlier, you described people who, under the old rules, were essentially stripped of their citizenship at age 28, and if they didn't successfully apply to keep it. So to me, this sounds like there are actually 2 groups still left out due to the 28 age rule. One group that never applied, likely because they didn't know they needed to, or another group that did apply, but were not successful because they didn't meet the criteria. Is that correct? Okay, so if these 2 groups are under the former age 28 rule, would they both of these groups, would they see their citizenship restored if S-245 is passed?
So the only group that would benefit would be those who never applied for whatever reason. The group that the bill doesn't include are those who applied and for whatever reason were not successful.
So if only one of the group is included in this bill, could this be considered as an inequality? And wouldn't this be subject to the government to open up a potential legal challenge for the government?
I don't want to speculate on the form in which the bill could be passed with or without amendment by the committee, but it would create differential treatment by those affected by those former Section 8 provisions. So in that, you are correct. And I think from the perspective of the experts at this table, we'd like to recommend for the committee's consideration that all of those groups affected by the former Section 8 have an opportunity to be remedied, but it would require an amendment to the bill.
So to your knowledge, how many people do you think are in the group of people who lost their citizenship due to the former age 28 rule, and how many of those people would be captured in this bill as currently written without the amendments?
Thank you for the question. It's difficult for the department to know exactly what that number would be, since we only have data with regard to people who come forward and apply. Currently, those who lost citizenship under the former Section 8 provision can come forward and apply for something called a discretionary grant of citizenship under Section 5.4 of the Citizenship Act. And a small number of those persons come forward every year to obtain a grant. And I have a statistic here, but I have to take off my glasses so that I can share it with the committee. Since 2014, 130 persons affected by the former Section 8 received a grant of citizenship under a discretionary grant of citizenship under 5.4.
Okay. So now these questions are going to be around the first generation limit. And I'd like to better understand how the first generation limit rule is applied and what the 2019 coming into the force date means in practice. And does that date only apply to certain people, depending on if they were born before or after 2009? Or did the rule apply to everyone as of that date, regardless of when they were born?
Yes, thank you for the question. So it is the latter. The rule is applying to everyone as of 2009. And so what it means is that for children born abroad after that date in 2009, they will be Canadian from birth automatically if they have one parent who was born in Canada or one parent who immigrated to Canada and became a citizen before their birth. If it's their grandparent who falls under one of those categories, then they are considered the second generation born abroad and they are not automatically citizens from birth. Their avenue to citizenship is through the permanent resident process, followed by a grant of citizenship.
Okay. I would like you to elaborate on something that I found very surprising in your presentation. You said that Bill S-245 seemingly looks to push the application date of the first generation limit from 2009 to 2015. Can you just add some comments on that?
I'm sorry, does the member have a specific question in that regard?
I just want you to elaborate on that.
So as I mentioned in my remarks, pushing out the date of the application of the first generation limit from 2009 to 2015 will essentially, it seeks to delay the implementation of the first generation limit to the later date, which means that those born abroad in the second generation or beyond before 2015 would automatically be citizens from birth. And so previously, since 2009, they would have had to obtain a grant of citizenship, and those who are granted citizenship have the ability to automatically pass on citizenship to their future children born abroad. By converting, with the bill converting those to become automatically citizens from their birth, it means that they're then impacted by the first generation limit and can no longer do so, which means that if they have children born abroad in the future, they'll be considered second generation and potentially lost Canadians, as I mentioned in my remarks.
Time is up for you.
Oh, okay.
6 minutes have passed. Thank you. We will now proceed to Mr. Brunel Desepp for 6 minutes. You can please begin.
Merci, Madame.
Thank you, Madam Chair. And thank you for your opening statements. Very informative. At present, the lost Canadians, those who have lost their citizenship, when they lose it, what happens? Do they have to leave Canada? I imagine so. Would you like an answer? Yes, of course. No. People who have been affected by the prior Section 6 who automatically lost citizenship, yes, there were some people living in Canada who were unaware that this provision actually applied to them and may have noticed this when they were renewing a passport, for example. As I said, there is a discretionary grant under subsection 5.4 of the legislation, which allows such people to put forward a request, to make a request to once again be granted citizenship. In 2014, I mentioned a certain number of people in such circumstances were granted citizenship because they had lost it automatically. I'm sorry, I'm not as an expert in this matter, but I think I understood that once you lose your citizenship, you have 30 days within which to leave Canada. Is that still the case? There is no particular provision to that effect. How many Canadians lost their citizenship in such circumstances in 2023? We don't have these figures available, but what I can state is that is a specific cohort, people who were 28 years of age before 2009. Moreover, this is a provision that is no longer being applied. So these are people who lost their citizenship just before the legislation was changed in 2009. Yes, the changes in 2009. At present, given the current bill, how long would it take for people to recoup citizenship for those who have lost it? Well, one of the concerns with the current wording of the bill is that there is no clause allowing the minister to prepare application and to facilitate application. Normally, it would take a year to prepare this, given that you have to make rules and regulations, take regulations and shift a few systems to be able to process the requests. But once the bill would come into effect, the provisions, the way they're written now, would be automatically applied. So when the bill would come into effect, these people would once again become citizens. And one of the concerns that was brought up, for example, by the Canadian Bar Association, if I may, is that there's no specific date for their remedied citizenship status in this bill, and we would consider that the committee might specify a date, and an amendment would be needed to do so. Just to give you a full answer. Yes, of course. Thank you. And, of course, there is a backlog of processing in citizenship and immigration. There are some structural issues. I, of course, understand that the minister is trying to improve magisters by hiring more staff. But what we hear right now in our offices is that it's still a difficult situation for immigrants, people looking to immigrate. About, 85% of our work in our offices is related to this issue. So if this bill is passed, given what's going on at Citizenship and Immigration Canada, we need to ensure that new officers are hired, that more staff is hired. I'd like to hear you on this. It's a bit of a complex question, of course, but given the issues already in the department, if this is a new program, would it be difficult for civil servants to put it into effect? I wouldn't say so. A lot of work has been done to modernize programming during COVID, and processing time is improving. There's still work to be done, of course, but we have had a record number of citizens who were brought in last year in 2002, 374,000 new citizens, which is a real record for Canada. Just to specify, when the bill would come into effect, those whose citizenship would be remedied, who are affected by Section 8 of the prior legislation, automatically would become citizens. And in their case, they would need to obtain from the minister some evidence that it's not that their citizenship is being put off, it's just a matter of having their evidence processed, and there's continual improvement on that front. All right, Ms. Fox came to us last fall before the committee and explained that citizenship requests, there were requests for work permits within a week, because right now it takes 12 to 14 months for refugees, claimants coming through Roxham Road to get work permit. And based on what we have heard, that hasn't panned out, even though that program was brought in the fall.
You will get an opportunity in the second round. We will now proceed to Ms. Kwan. Ms. Kwan, you will have 6 minutes. You can please begin.
Thank you very much, Madam Chair, and thank you to the officials for being here today. For sure, the Citizenship Act is a complex file with so many changes over the years that amendments brought to the table often would require amendments to the exception, and so on. So extremely confusing. From my perspective, first off, I'd like to, of course, say that we have before us S245, and I do want to acknowledge and thank Senator Yona Martin for bringing this before us, because it gives us an opportunity to look into this issue and see how we can fix some of the problems. Maybe it's never going to be possible to fix all of the problems, but I think it would be important and incumbent for all of us to do our very best to try and fix as many problems as possible. So I appreciate the briefing in terms of you highlighting some of those areas. On the question around unintended consequences, I'd like to actually probe a little bit deeper into this issue around other countries, where if you were to confer citizenship to the individual, that it might cause them a heap of trouble, because in whatever country that they might be in, they might not be allowed to, for example, have dual citizenship. Now, this situation, of course, conferring citizenship automatically in this way was done before. It was done under Bill C-37, it was done under Bill C-7, and so on. So it's been done before. And somehow it was dealt with in those previous scenarios. I get it that times might have changed. There might be more people who are living globally, but nonetheless, the premise of that has not changed. So can you advise how did officials address those issues back then? And why it was okay then to confer citizenship without these concerns of unintended consequences, but now it is a key concern.
Thank you, Madam Chair, for the question. The member is correct in the sense that the risk of unintended consequences then or now is going to continue to be there. I think for the consideration of the committee, one of the things that we've become more aware of, or certainly I've become more aware of since 2009, in working on lost citizen issues, is that it's right for there to be a remedy. This is, the principle of the bill is something that the government can support. The question is a bit on the mechanism. So, as the other member was mentioning previously, the first part of this bill is looking to address a narrow cohort. There are a limited number of individuals left who were affected by the former Section 8 and who lost their citizenship automatically. And so in some sense, it makes sense in terms of the provision of the bill to restore those individuals their citizenship, or at least that's what the bill is looking to do. We've become a bit more aware since 2009 about concerns in the international sort of community of experts about this issue of unintended consequences, especially where there could be countries that may still have laws on the books where people who take out another citizenship could automatically lose the citizenship that they have. They could be working in a profession where dual citizens may be barred, and it's not a theoretical issue. There were media reports of a dual citizenship crisis in Australia in 2017. There were more than 12 members who resigned from their position when it was found that those individuals were in circumstances of where they had dual citizenship, and Australian law was not permitting dual citizens to be members of Parliament. And so I think the question for this committee is on the remedy, other than the Section 8s, for the remedy for others who are sort of described in this bill. What is the mechanism? And there is a reasonable argument that a mechanism could be made available, potentially through amendment, for those born abroad in the second generation or beyond who can demonstrate a connection, but on application, so as to minimize this kind of unintended consequence. Because for that provision in the bill, we're talking about very, very large cohorts. We're not talking about the narrow group of Section 8s who would be restored automatically.
Or alternatively, we can do it in reverse, and that is to say that for those who might be in an international country, in an international community, do not wish to have Canadian citizenship conferred to them for whatever reason, that in fact that could be made to happen. So they could actually say, oh, gee, all of a sudden I realized somehow I got Canadian citizenship that I didn't want. I would actually like to have that rescinded, retroactive to the date of when the bill was passed. So then, so those small cohort of people who might be impacted they have a pathway to ensure that they are not going to be impacted. So that could be done. The suggestion to which you're saying, well, everybody who should be able to get citizenship and want to get citizenship should apply to get citizenship, to my good colleague, Ms. MP Brunel Decep's comment, already as it stands, immigration is inundated with backlog. And with more applications coming in all the time. And so why would we create a scenario where you have more work for officials and for the people to go through, minimize the amount of people who might be making an application and still keep them whole?
Sorry
and
for
then doing
interrupting.
it in reverse onus may be a better option. So just a quick comment from the officials on that.
Your time is up. We will come back when you have the second round. So we will now proceed to Mr. Redekop. Mr. Redekop, you can please begin. You will have 5 minutes.
Thank you, Madam Chair, and thank you to the witnesses for coming. I just want to go into the numbers a little bit. I'm a numbers guy, so I'm curious about that. I've noticed you mentioned the 130 that have been granted 5-4 citizenship granted by the minister over the past, but I haven't heard much else, and I'm sure that as you've looked at this legislation, you've done some work on rough estimates of numbers of people that would be affected. So I just wondering if you could share some of that information with us.
Thank you for the question. Those affected by the Section 8 are a limited cohort, and I think we've shared a bit of a backgrounder with the members of the committee that in recent years we've seen perhaps 25, 30 such persons come forward seeking a grant under Section 5-4. And so we don't anticipate the numbers to be all that significant, but those are the ones that are coming forward now. So it may be more than that. It's difficult to know exactly how many would come forward.
So can I
yes.
just interrupt? You mentioned that report, and by the way, that was a good report. I'm assuming you or your department did that briefing, and that was very good information. But there were no numbers in there, and I find it difficult to believe that nobody asked that question of, are we talking 10, 100, 1,000, a million? Like, what's the quantity here? So there must have been some kind of number of work done in the department, or no. I mean, if there's not, just say so.
For the Section 8 provision, we don't think that the numbers would be all that significant. For the other provision of the bill that's moving the first generation limit from 2009 to 2015, so those persons would be getting citizenship automatically. Again, it depends how many people decide to come forward to seek documentation from the department. But that particular provision would affect untold numbers, at least in the tens of thousands, and it could be more than that. But again, it would depend on how many came forward. And as a reference point, we did include in the briefing deck, which was shared with committee, that the 2009 and 2015 amendments together have resulted in close to 20,000 persons who have obtained a citizenship certificate from the department.
Okay, thank you. And I just want to stay on the topic of how citizenship is important, and it's an essential part of this country. I hear from a lot of newcomers in Saskatoon and throughout the country that they're proud to come to Canada, proud to settle here and get a job, make a life for themselves, and they're contributing to our country for sure. And they don't take citizenship lightly. They're not coming here to, get welfare or Canada pension plans. They're not coming for some dream of universal basic income where they don't have to work, and because newcomers cherish citizenship, and likewise some have lost citizenship because of government errors, and that's exactly what we're talking about here. Bill S-245 will fix that for a certain small group of people. And of course, as Conservatives, we value citizenship, and we're not going to extend citizenship just to anybody that wants it. On the other hand, the Minister of Immigration has announced a plan to devalue citizenship by replacing in-person citizenship ceremonies with a one-and-done click on a website. So no ceremony, no physical connection. In fact, you wouldn't even necessarily need to be in Canada to click that button. And so, Madam Chair, at this time, I'd like to just give a verbal notice of motion. I believe this has been sent around, and it's this: that the committee calls on the government to prioritize granting citizenship to new Canadians through in-person ceremonies, allow virtual ceremonies only if specifically requested by the individual when in-person ceremonies are impractical due to health or safety concerns, cease citizenship by self-administer a digital oath signed by attestation as announced by the Minister of Citizenship and Immigration on January 31, 2022, have department officials appear at this committee for 1 hour to answer questions on this topic, and that the committee report this to the House. So I put that on notice. My question for the officials is about this self-administer a digital oath signed by attestation idea, as the minister described it. If you agree that newcomers feel a sense of pride and joy when they take that oath of citizenship with other immigrants at an in-person ceremony, why is the government moving in the other direction?
Thank you for the question, Madam Chair. As outlined in the regulatory impact analysis statement that's publicly available, the primary rationale is to increase the flexible authorities for the way in which the oath can be administered, and to provide an electronic option that people can self-select in the future if they wish to do so. But I think what has not come out as clearly, perhaps in some of the public commentary, is that ceremonies will continue because they're important events to mark a significant and important occasion, as the member has mentioned, and those ceremonies will continue. However, those who may have this option in the future, could face a variety of circumstances. They may be in a remote location. They may need to travel. They may need a form of accommodation.
Sorry for interrupting. Time is up for Mr. Reddycop.
Thank you, Madam Chair.
We will have to move to the next member. Mr. Dhaliwal, you will have 5 minutes. You can please begin.
Thank you, Madam Chair. I want to thank the great presentation and questions and answers that's going through. Even though you are explaining very well, but I represent a riding where over 100 countries, people from 100 countries have migrated to Canada, and many of them, probably fall in this this bill will either help or not help. So I'm just going to ask you a few more questions, going back to first generation. I'm sure people like Mr. Lawrence will understand better than engineers like myself, when it comes to these complex legislation. When I read this bill and presentation you made, my understanding was that that this legislation S-245 would automatically confer citizenship on to a relatively small group of people. And just some of those impacted by the former is 28 rule, but now it sounds like there is potentially a much bigger number of people that it will affect. Do you have the idea how many people might also be granted automatic citizenship if a first generation limit date is moved?
We do not at this time have the ability to have an accurate estimate of how many may be impacted by that change, but it would be all those born abroad since between 2009 and 2015. Those aren't numbers that we track, but it's untold numbers. It could be in the tens of thousands or more in terms of order of magnitude.
And what could be the negative consequences of automatically giving citizenship to a much larger group of people?
Yes. So as I was mentioning earlier, those since 2009 impacted by the first generation limit are not receiving Canadian citizenship automatically and have had to apply for a grant. And generally, those who obtain a grant of citizenship are able to pass on their citizenship automatically to a child that they have who would be born abroad. What the bill is doing is instead making those individuals citizens, automatic citizens by operation of law, and they would be subject to the first generation limit, which means that they can no longer pass on a citizenship automatically to their children who are born abroad. So whereas before they could, if the bill passes without amendment, they would no longer be able to. And the concern is that could create future lost Canadians in terms of children who would be born abroad and no longer have access to that automatic citizenship through their parents.
Would there be any negative consequences when it comes to security and criminality if we automatically, confer this citizenship?
I'm sorry, I'm not sure I fully heard that. Could you repeat the question?
When we do this, do you take into consideration the security and the criminality when, automatically we can grant those citizenships? I
see. So when it comes to automatic citizenship, those are not considerations because the law is conferring citizenship automatically. It's those kinds of considerations in terms of criminality or security concerns are looked at when individuals are applying for a grant of citizenship because it's part of the requirements. That individuals are barred for criminality or security reasons when it's on application and it's a grant of citizenship. But the bill is not laying out a grant as the mechanism. The bill is providing automatic citizenship as a mechanism.
It is my understanding there is a mechanism in place if government or department want to revoke the citizenship. There are avenues available in the Act at this point in time?
There are avenues in the Act at this time, but those avenues are generally relate to individuals who have applied for their citizenship through a grant. For instance, if they may have misrepresented in obtaining their grant, perhaps they may not have met their requirements, or somehow, despite rigorous checks being done, they may have somehow managed to conceal that they had criminality, which may have made them ineligible for citizenship. Those are provisions which apply to grants of citizenship. I'm just going to turn to my colleague from the Department of Justice in case...
Sorry for interrupting. Time is up for Mr. Dhaliwal.
Thank you.
Thank you, Madam Chair, and thank you,
Mr. Dhaliwal.
Director General Gerard.
Yeah. We will now proceed to Mr. Brunel Desep for 2.5 minutes.
Thank you, Madam Chair. I know that Jenny has been working very hard on this file since 2015, so I will turn my time over to her.
Thank you so much. I really appreciate that. Maybe I can get a quick answer first from the officials to my last question.
I'm sorry, Madam Chair, could the member just repeat the question?
Yeah, it was just very quickly on the issue around those who are in outside of Canada in an international community, and the issue of doing the reverse onus. Instead of having people to apply to have their citizenship conferred to them, that we would actually get the people who don't want their citizenship conferred to them to apply, and that it would be retroactive to the date of the passing of the legislation, so as to save really IRCC resources to not having to deal with a larger number of applications.
Yes, thank you, Madam Chair. So there is a provision under the bill to allow for a simplified renunciation for those who don't wish to have it. I can't speak to whether the bill would provide authority for retroactivity or not, but perhaps my colleague from the Department of Justice may have some comment on that.
Well, the bill doesn't provide for it, but if an amendment were made to the bill to provide for it, I'd love to hear what Justice think about that.
So I think if I understand the question, it's opt-in versus opt-out. I mean, anything can be done with a bill subject to the will of the committee and the will of the House of Commons and the will of Parliament. There are very few restrictions in terms of legislating retroactively. There are some constitutional restrictions. But I think the question is perhaps more from an operational point of view is both opt-in and opt-out would require an application. So in terms of managing the workload, I guess that would be more for the department to determine. But you would have applications for both of the scenarios you've mentioned.
Correct. But so from Justice's point of view, then you're not concerned if we were to do the opt-out scenario that the unintended consequences then is therefore not addressed. I guess that's really more my question.
Okay, so it would be a policy call for this committee and the House of Commons to decide. I would just note that we have to be careful because, for example, the opt-out one would have to look at the national legislation, the nationality legislation of the other country in question, because there may be potentially still issues in terms of unintended consequences. Those countries might not recognize, for example, retroactivity in terms of a concept. So it might do away with that problem, depending on the legislation in question of the country in question.
Right. Well, I think there are a number of ways to skin that cat, so to speak, because the person can apply to opt out, or alternatively, for those who wish to opt out, the application of this automatic conferring of citizenship would not apply to them. So I'm not a lawyer, but I'm sure that there are lawyers who can figure out the language of how that could be done to prevent those kinds of unintended consequences. I just want to note, because on that issue, previously, this bill, this concept existed before. It really never was an issue until it surfaced, and then, there are ways to sort of deal with it. And then, but instead of, I hope that we don't take the perspective to say, because this might be a problem, so therefore we're not going to do anything. Because if we take that approach, then I guess, what is the purpose of existing in life, generally speaking? Because everything is needing to sort of address one way or another, including getting up to get dressed in the mornings. Okay, so on a separate piece related to this, on one of the issues, because I hear a lot about how this bill is not comprehensive enough as a major concern and a series of concerns that's been listed. If amendments were to table to broaden the scope of the bill, even though it would be deemed to be out of scope, but there's a provision or a way to sort of get around that, and that is to go through a royal recommendation if the minister is in agreement. If that were done, would the department be opposed to looking at measures that expand and try to capture those lost Canadians so that we're not constantly dealing with issues of lost Canadians, at least give an attempt to try and catch as many as possible through amendments in this bill?
Thank you for the question. I can't speak to the procedure, but I think as already mentioned, because the bill is benefiting some born abroad in the second generation and not others, from this vantage point, it would be preferable during the amendments process to see if it would be possible to have a more equitable approach and solution in the amendments, as the member has mentioned. I think, as mentioned, there would be different ways to come at it and different risks. But that is for the committee's, rightly as you've mentioned, that is for the committee's consideration.
Yeah, one thing to do
time is up,
actually,
Ms. Kwan.
Sorry, can I just finish the sentence?
Time is up. I was indicating, so we will have to go to the next member, Mr. McGuire. You will have 5 minutes. You can please.
Thanks. Jenny, I'll give you time to finish your question. Go ahead and finish your question.
Oh, my God, thank you. Oh, okay. I guess one way then to address this whole situation.
Need a microphone.
Comprehensive. My mic is on?
It wasn't on.
It's not working? Oh,
It's on there.
so one way to address this as comprehensively as possible is to rescind the provision that came in to say that those who second generation born would not have their citizenship conferred to them. That would be an easy way to actually deal with it. Would that something that the department thinks is advisable?
I'm not sure I can advise that or comment on that, but another way to come at it would be to leave the first generation limit as is and have a mechanism that's equitable for those who were born abroad in the second generation or beyond to access on demonstrating a connection test.
Yeah, and so what we're talking about then is an application process, which already exists, by the way, and people can apply, and is an onerous process and an ineffective process, and that people are saying, don't go down that route. So I would think that we don't want to repeat history and learn from that experience, and maybe it's a safe way to do it, but I don't think so.
McGuire is asking for his time.
I meant that you could ask.
Yeah.
No, you could ask your question, but. Oh, sorry. Madam Chair, I just wanted to, in regards to Mr. Kamick's question earlier about the number of lost Canadians in this, I wonder if the witnesses could table an analysis on the total number of lost Canadians or a projection of the total number of lost Canadians that are involved here. Is there an analysis that they could table with the committee, please?
I think, as I've mentioned, the cohort impacted by the former Section 8 in the range of 25 to 30 such persons who come to forward to the department every year, because there are those who lost their citizenship automatically at age 28 before 2009. So it's a limited cohort, likely in the range of those kinds of numbers we would see come forward. Depending on what the committee may wish to do with the provision that Deputy Kwan was just mentioning, that particular provision, moving the first generation limit, would have impact on untold numbers of persons born abroad, in the tens of thousands or more.
Okay. Yeah. Yeah, no, thank you for that. I'm just wondering, on average, this is maybe similar, but how many people a year are shocked to find that they aren't Canadian citizens when applying for a passport?
So we have had, as I mentioned, 130 such persons who came forward and received that discretionary grant because they had lost their citizenship automatically due to Section 8. So it's a limited cohort, as mentioned. It's not significant numbers.
Yeah, and that was the number that between that 50-month window between February 15th, 77 and April 16th, 81
Yes.
that you're referring to?
Correct.
Yeah. Previous government streamlined the process for people receiving the citizenship through ministerial discretion by eliminating the necessity to be at the Treasury Board or to go through the Treasury Board Cabinet Committee's approval. Did that process help at all in speeding up the process?
Madam Chair, I can't comment on the timelines for that process because it may vary from one case to the next. But my understanding is it's a timely process for those going through.
Maybe it didn't. I don't know.
Going through the 5-4 process for the reasons that the member mentioned. It's not a cabinet process. It's done in the department.
Yeah. We've heard reports that some of the lost Canadians have received their Section 54 ministerial grants in their favor after many years of waiting. How long on average does that process take?
Madam Chair, I don't have that statistic to hand today, but we can follow up with the committee and determine what it's feasible to provide and provide it in a timely fashion.
Thank you. Would having this legislation pass, make the situation of lost Canadians impacted by this legislation more difficult, or more efficient for the IRCC functions? And I'm assuming that the bill would reduce inquiries and streamline the process in some cases.
Yes, the member is correct, because particularly for those impacted by Section 8 who've lost their citizenship, they'd no longer need to come forward for a discretionary grant, which is addressed case by case. The circumstances may be different and vary, and they would become citizens automatically by operation of law and need to apply for proof of citizenship should they wish to have evidence of their Canadian citizenship, which is a fairly straightforward process.
Okay, time is up for Mr. Maguire. We will now proceed to MP Ali. MP Ali, you will have 5 minutes. You can please begin.
Sorry, Larry, I really misunderstood you.
Thank you. Thank you, Madam Chair. Thank you, the officials, for being here. My question is to you that you have said in your presentation that there are existing remedies for everyone who still considers themselves a lost Canadian through an immigration process or applying for a grant of citizenship. Can you explain what the different grants are that exist? What criteria would someone have to meet in order to be successful in their application?
Madam Chair, thank you for the question. That's correct. There are existing avenues. So the one that we were just speaking of, the discretionary grant to the minister, application to the minister for the discretionary grant is on the basis of hardship or unusual hardship. And certainly that would describe those who lost their citizenship automatically due to the former Section 8 provisions. So that's one option. The other avenue for those born abroad in the second generation or beyond since 2009 who are no longer automatically citizens but have a Canadian parent, the parent has the option to sponsor their child for permanent residence in Canada. Once the child becomes a permanent resident, through that avenue, there's no waiting. The parents can then apply for a grant of citizenship for the child. And certainly there are some requirements, but the main one in that circumstance is that they have a Canadian parent. who is going to apply on the child's behalf so that the child can then become a citizen.
Thank you. Through you, Madam Chair. I'm trying to better understand how it works. Particularly speaking, for someone to obtain one of the special grants you have talked about. So let's say I have looked at the grant criteria and decided that I meet it, and I decided to make an application. What is the specific process from the time IRCC received my application? How long before I find out if I have been successful?
We don't have the processing time to hand today, Madam Chair, for the discretionary grant of citizenship, but I have undertaken to go back and assess what it's feasible to provide, and to provide that as soon as reasonably possible to the committee in response to the member's question.
Thank you. Your department has faced with the large backlogs after the pandemic. Would an automated grant not help to relieve some of these pressures rather than having another application process that could further add stress to the system?
Thank you for the question. As mentioned, the department has undertaken a number of modernization measures over the last couple of years. It brought applications online, and we conduct online tests and online citizenship ceremonies, as has been mentioned. Resources have been added, and significant progress has been made to reduce inventories and processing times. In the grant of citizenship business line, there's still more work to be done, and the department is working hard to continue to improve its service to citizenship applicants. Though as I mentioned, we had record grants of citizenship last year. Where the bill is extending citizenship automatically to some under the bill as drafted, those applications would be instead for a proof of Canadian citizenship, which is the smaller business line, if I can put it that way, because the grant business line for newcomers, immigrants to Canada, is the much larger one. As I mentioned, we had 374,000 new citizens last year. The grant business line is more in the tens of thousands by comparison. And those who, under the bill, may wish to come forward and have evidence of their Canadian citizenship would need to actually apply for what's called a proof of citizenship. And the department would undertake the necessary implementation preparations to be able to issue those if Parliament passes the bill, and then we are called upon to implement it.
Thank you. Time is up for you. We will now proceed to Ms. Trempel-Garner. Ms. Trempel-Garner, you will have 5 minutes. You can please
Thank you,
begin.
Chair. And if I may, compliment you on the lovely baklava that you provided.
It's a very Scarborough special baklava.
Well,
owned by a
Scarborough
Syrian
really
refugee.
produced some delicious baklava, and I would like to say that this is in scope, if I may. And I'm buttering you up because I move that, pursuant to Standing Order 1082, that the committee extend the total number of meetings currently allocated to the current study regarding the government's response to the final report of the Special Committee on Afghanistan by a minimum of 3 meetings to be held prior to March 31st, 2023, and B, Senator Mary Lou McFedrin, MP Mark Garneau, Minister Harjit Sajjan, and Minister Marco Mendicino be invited to appear separately before committee prior to March 31st, 2023 for 2 hours each to discuss matters related to the current study. And C, Dr. Lauren Oates of the Canadian Committee for Women in Afghanistan Group be invited to appear individually before the committee prior to March 31st, 2023 for 1 hour to discuss matters related to the current study. And D, summonses do issue for the appearances of former Minister of Women and Gender Equality Mariam Monsef, Ms. Laura Robinson and George Young to appear separately for 2 hours each at the dates and times to be fixed by the chair, but no later than March 31st, 2023, to discuss matters related to the current study, and summonses due issue for the appearances of senior departmental officials from the Department of National Defense to appear before the committee at a date and time to be fixed by the chair, but no later than March 31st, 2023, to discuss matters related to the current study. And, Madam Chair, I did move this previously on February 8th, 2023. Thank you.
Just in regards to your motion, just one. Okay. Yes, Mr. Redico.
Thank you, Madam Chair. I would like to move an amendment to this motion, and it's just a technical amendment, and that is I would move that we replace all the instances of the word March 31 with April 30th, and that we would add the word former before the reference to MP Garneau. So those two changes, March to April, former in front of Garneau.
Mr. Al-Khoury.
Thanks, Madam Chair. I believe it's unfair for the witness to stay completely 2 hours without at least 2 minutes break. So if my colleague agreed to give them 2-3 minutes break to relax, and it will be appreciated. Thanks.
I've been advised, just to clarify to all the members before we go further into this, the debate was adjourned on this motion. So, if we have to assume debate on that, someone has to move the motion that the debate has to resume. So, and then we will have to vote
I'm
on
sorry,
that.
I thought that's what I said, was to resume debate on the motion moved on February 8th. Yeah.
We will have to vote before we proceed further. We will have to vote on this, that we can resume debate
right?
on this.
Procedurally correct?
No,
No,
I can ask the clerk to clarify. This is what she has said. Madam Clerk, if you can please clarify that.
No, why? It's
Just
a
for
live
2 minutes.
motion
She's
on the
checking
floor.
on. She's just clarifying. Before we proceed further.
Point of order. Point
yes,
of order.
Ms. Rempel-Garner.
I believe procedurally you are out of order on this. It is a live motion on the floor. I was recognized by the chair. The motion has already been put forward by committee and motion has been deemed. And I moved it. This is a live motion that's before the floor, and we should be continuing with debate on the amendment.
The clerk is just checking. She advised that, so she is just reconfirming, because this is what she provided the advice, that we have to have a motion to resume debate. Yeah, so she's just, before we proceed further,
Point of order,
I would wait for the clerk to...
Point of order.
Yes,
the clerk
Ms.
is not a member of the committee, and it is procedurally in order. So if you are making a motion that is procedurally out of order, which I don't think you are, because it wouldn't be, I just, technically, Chair, I don't accept setting a precedent where we suspend for a member who's not a part of the committee to intervene in the committee's proceedings. It's not technically correct. So we should proceed with debate on the amendments, proceed with the debate then on the motion, and carry forward.
Mr. Dhaliwal.
Thank you, Madam Chair. Madam Chair, you are doing an excellent job as chair. Time to time, I'm sure, Madam Rempel Garner, you know that chair has always discussed have taken advice from the clerk, and I think that's exactly what she's doing right now as a chair. It's very fair to give a couple of minutes for chair to make those decisions that has to be made. So I would love to see this meeting suspended for a few minutes.
Point of order, Chair. Again, there's no procedural correctness in what's happening here, and we have to be bound by procedure. And wishes and thoughts and hopes are not the 800 to 1,000-page book on parliamentary procedure that we are bound to. So, Chair, we need to proceed with debate on the amendment that is ahead of the floor. Thank you.
So with all due respect, I'm just wondering, it's the third time that the member is interfering and saying certain things, and every time she says, I move to the following motion. Never once did I hear that she's actually moving to resume debate. So, Madam Chair, with all due respect, I'm asking that we suspend this meeting so we can talk. We do have officials who are here who were prepared to hear about legislative bills that we have to go forward. That was a motion that was unanimously passed last time in consideration the importance of legislation first. This is why we're here. I would like to adjourn this, suspend this meeting at this time, Madam Chair. Thank you.
And that's fine. I understand you don't want to vote on this. Well, the meeting hasn't been suspended, so point of order, Chair.
Okay. Can I have the attention of the members? Ms. Rempel-Garner, when you started reading the motion, did you say that I want to resume debate on this motion?
What are you advising, Chair?
No, I'm just I just want to clarify because the clerk has asked me to check that with you. Did you say that to resume? If I am just have silence from both sides, let me...
Okay, so, Chair, just to clarify, this is my time, right? Okay. I move that we resume debate on my motion from February 8th, 2023, that previously was adjourned, per the text that I just read before.
No, I never suspended.
But I will, Chair, clarify that you also turned to Mr. Redekop and accepted an amendment to be brought forward on my motion, and by doing so, I would say that you deemed the motion admissible in the way that I put it forward. So, I mean...
Okay, so Ms. Rempel-Garner has moved a motion and she has asked for the debate to be resumed on that. Yes, Mr. Redekop.
So do I need to remove my amendment then?
We do.
Okay, all right. So Madam Chair, I would move to delete every instance of March 31st and replace it with April 30th, and also add the word former in front of the reference to MP Garneau.
Amendment, Mr. Dhaliwal.
Now, as we are going into the debate on this one, I would request...
Can I have silence? Can I please request members to have...
I would respectfully ask you to give officials a 5-minute break so they can use the washroom and whatnot. So I would really appreciate, within the meantime we are debating, I would love to get this done somehow, one way or the other. You don't need to suspend the meeting because we're already going through the debate, and the officials don't need to watch that debate sitting here.
Yes, I just would like to check with the officials. Would you like to stay or would you like to leave the meeting as this has, the debate has started on the motion which has been moved by Ms. Rempel-Garner?
Madam Chair, we can take a 2-minute comfort break to allow the committee business to proceed, but we're here to answer your questions, so we'll be pleased to come back and continue to answer any questions that the committee may have, Madam Chair.
Okay, that's fine. Mr. Al-Khouri has the turn now.
Yes. Madam Chair, don't we need a vote in order to resume debate? Can you check that, please?
Resume debate? Is it the will of the committee to resume debate or the...
We should take a vote.
No. So we will take a vote because if some members are requesting, so we will take a vote on that.
Point of order.
Is it the will of the
Point of
committee? Yes, Mr. Kimmich.
Pardon me, Madam Chair, but I have been on many committees now. I have never yet seen the resumption of debate on a motion that is live and has duly been put on notice, has been debated several times by a committee, that we then proceed to a vote. I've never seen that done at any other parliamentary committee. The motion was not voted down prior at committee. The procedures for committee business are that if it's been duly put on the notice, as per the rules that this committee has set about, that any member may move or resume debate on a motion that has yet to be resolved by the committee. And now we have even an amendment to that motion. So there's no vote to be had, Madam Chair. The way I understand the procedures that are done, we are supposed to be debating it. If there's no speakers, then we would proceed to a vote on the amendment and then on the main motion, which I can say I'm not going to say anything else. I don't want to prolong the meeting because I do want to go in camera to deal with Mr. Brunel-Lucep's points about the meeting of that delegation. So there would be no vote procedurally, Madam Chair, I believe, on whether you can resume debating a motion that's been duly put on notice and that is live before committee because it has not been resolved yet.
Thank you, Mr. Kimmich. I have consulted the clerk and she has said that if there is no objection, then we can proceed. But if there is an objection and some members are pointing out that there should be a vote, then we have to have a vote. Because the debate was adjourned on this motion and now we are bringing it back. So as per the clerk's advice, if the members are objecting, we will go into a vote. So we will vote if we want to resume the debate on the motion. So Madam Clerk, if you can please take the vote.
Point of order, Madam Chair. Can the clerk please provide the committee then the exact page where this rule is in place? Like I'm looking to the other members of the opposition here. I have never seen something like this happen before a parliamentary committee.
Je suis complètement d'accord avec.
I fully agree with Tom. I think he's right across the board. Let me say, though, if I've got a moment, Tom, the explanation he gave, it's true. So I really don't understand why we're intending to vote on the possibility of debating something. Tom is right.
We'll ask the clerk to clarify if it's on the...
If the committee gives its implicit consent to resume debate, then we may resume debate.
So do we have the consent? Mr. Ali.
Thank you, Madam Chair. I would ask my colleagues, I don't see any harm of resuming the debate because it was adjourned and it was a live motion. So I think I would request my colleagues, so let it resume the debate.
Here we go.
Thank you.
If all the members are saying in favor, we will proceed. So we have the amendment on the floor. Ms. Kwan.
Thank you. I'd like to move a sub-amendment. Before I go to that, can I just hear, there was a lot of talking going on. I didn't quite hear exactly what the amendment was. I apologize. Can we just hear it again, what the amendment is?
You can please repeat.
Thank you. So I move that we replace every instance of March 31 with April 30 and add the word former in front of the reference to MP Garneau. So effectively, we're moving it a month.
Got it.
Ms. Kwan, are you clear now?
Just want to take a picture of this.
Ms. Kwan.
Yes. Sorry. That picture. Okay. Well, thank you. Thank you for this. Speaking to, I guess I'm technically supposed to speak to the amendment, and I don't have trouble amending the timeline as proposed, but I would like to move some sub-amendments to the motion, to which I like to move that we delete clause C, which calls for Dr. Lauren Oakes, the Canadian Women for Women in Afghanistan group.
Silence in the room so that everyone can understand what sub-amendment she is proposing.
Okay. So I'm moving, Madam Chair, sub-amendment to delete clause C, which calls for Dr. Lauren Oakes, the Canadian Women for Women Afghanistan group, be invited to appear individually before the committee prior to March 31st, 2023 for 1 hour to discuss matters related to the current study. And I would like to move to delete clause D as well, Madam Chair. And then finally, I would like to move a sub-amendment to change in clause E the word summons to invites. Let me just explain why I have moved these sub-amendments, Madam Chair. First off, for Dr. Lauren Oakes, who is a representative of the NGO doing incredible work in very, very difficult times in Afghanistan. And I know that she also has staff that worked in her organization who are actually in jeopardy at the moment. They need to get to safety, but unable to do so, to which, of course, I have lots of questions for the government in their inability to bring these individuals to safety. And she is, on this question, she is the only person who is from an NGO asked to come. I think at this point, given the situation that we're dealing with, it would be appropriate to have these various people listed under Section B to come before the committee. I think that is entirely appropriate for that to happen. But I don't think that Lauren Oakes should be required to come unless if she wants to come. So I would move that we actually strike that clause out and through the clerk can invite Dr. Lauren Oakes to send in a submission if she wished to do so in terms of her perspective and views on the matter for committee's consideration. On D, I'm generally not opposed to having former ministers or ministers, for that matter, come before the committee. In fact, I think accountability rests with ministers, whether you're former, if a matter were related to you at the time when you were minister, you should come before the committee to answer these questions. Now, in the case of former Minister Mariam Monsef, it is my understanding that she just had a baby. And I guess, new mom is can be a difficult time insofar as it's being so new. It's a happy time as well, having been a new mom so many years ago for me now, 19 years to be more precise. And I remember those days. There were days that I couldn't barely get up. Like literally all day has gone by and I have not brushed my teeth yet. I'm just scrambling, trying to, do all the stuff that I'm supposed to do as a new mom. Anyway, it's a bit of a thing, and so I'm a little bit, I want to just extend that courtesy for her because I think it could be difficult for her to be away from her baby. I know it's a short period, perhaps even is saying that it's just for 2 hours, but still, just sort of give that provision. Maybe there's another time to which we can invite her that might be more convenient for her, perhaps, and we can certainly entertain that. With respect to former staffers, Laura Robinson and George Young, I would say this at this time. There may be times where I think former staffers would be appropriate to speak as well. We're hearing that, in fact, although not a former staffer, but a current staffer from the PMO's office on the foreign interference question. The NDP actually supports and moved, my colleague Peter Julian actually did move to have Katie Telford to come to committee on the foreign interference issue at their committee. But in this instance, with these former staffers, what I would like to do first is to have their bosses, their former bosses, come before us. That is, the ministers to come before us to answer pertinent questions. And then after which, if there's a determination where it would be necessary or deemed to be necessary or appropriate for us to call and to invite these former staffers to come before us. And I think we still have an opportunity to do that. That's why at this point I'm suggesting that, Madam Chair, for us to remove Section D. And then finally, on the word around summons in Clause E, I don't know, I think we had this discussion at some other time with respect to having individuals come before the committee, including ministers, and I was told that we're not really able to summon them, and that rather that's really the House, if the matter is such that they don't come, and in this instance I'm talking about the ministers with the Afghan file. We were frustrated as a committee that those ministers were consistently unavailable and then never offering a date. And we were frustrated with that process, and I wanted to summon them. And then I was pretty well told, no, you can't summon them. You can ask them to come, and if they don't, and then by a certain date, then the committee can then report the matter to the House. Then the House, through the House, can take further action, including summoning them to come before the committee. So in the spirit of that, that's why I'm proposing that we, instead of use the word summons, that we use the word invites. So that's my thinking behind this, Madam Chair, and otherwise I'm fine with the change on April 31st. I'm fine with the former MP Mark Garneau piece as well, because that just reflects the current reality of things, and I'm looking forward to having these witnesses come before the committee, because the Afghan file is an important one, and people's lives are at risk at the moment, and is something that I really do want to have our committee work on. Thank you, Madam Chair.
Thank you, Ms. Kwan. So you mentioned that it's like a sub-amendment, so it is not related to the amendment which was proposed by Mr. Redekop in regards to changing dates. So I would seek committee's members' consent that should we deal with this, what Ms. Kwan is proposing first, and then go on to changing the dates, which Mr. Redekop, if that's the will of the committee, we can proceed that way. So Ms. Kwan has moved some amendments. That's what we will be going into it. So, Ms. Rempel-Gardner.
Thank you. On the sub-amendment, I would agree with my colleague on her assessment of former or paragraph C. The reason why Dr. Oates was included in the original motion is that Dr. Oates is referenced in an article from, I believe it's November 2021, where she speaks about a unnamed senator essentially assisting her organization with people that were affiliated with her organization with documentation that is at the subject of this. And I think it would have been material to know if she had received some of these documents from the senator, because that does say that the process was circumvented for some groups and not for others. I understand her hesitance, though, in wanting to not be here. On the other hand, in that article, I will point out to her and put on the record that she is cited as saying that it was either her or someone else in the article that they knew that this senator went too far. And so I it just bothers me that we potentially had people who are probably very well-intentioned and do great work right now, working on a process that they may have had suspicions was not legitimate. That's not how we do business in Canada. We should be working to change policy, not to circumvent policy, even in the toughest of situations, because that's how we keep processes fair and equitable for everyone. I do have to take issue with my colleague's suggestion for point D, and I want her to listen why. I refer her attention, through you, Chair, to an article published by the Globe and Mail on February 17th, 2023, and the headline of the article is, Sajan unclear on whether top advisor told him he was sharing Canadian government travel documents with senators. And this, of course, this article refers to Mr. George Young. Mr. George Young is at the center of this entire matter. This is the former Defense Minister's former Chief of Staff. This entire article talks about how Minister Sajan couldn't recall or maybe recalled giving this person a potential documents. And I'm going to read from the article for my colleague, through you, Chair. And this is an interaction that Minister Sajan had with the reporter. Mr. Sajan further confused the matter on Thursday. In a brief interview with the Globe, he dodged 10 different questions about whether he knew Mr. Young provided what are called visa facilitation letters to Ms. McPhedran. So I would argue that Mr. Young is material to the committee's study of this matter, given that Minister Sajan has already had a long interaction with the press wherein he has tried to obfuscate on whether or not he knew or had given permission to Mr. Young for the use of these facilitation letters. I would also point out to my colleague that Mr. Young has used the excuse that he might be invited to this committee as rationale for not commenting to the press or providing further public comment on this matter. So for me, the most important person out of anybody to attend this committee hearing, frankly, the two people are Senator McPhedran and then George Young as our first starting place, because my understanding, based on everything that's come out in the press and my understanding on the files, is that Mr. Young is at the heart of this. And we need to know whether or not the former Minister of Defense authorized a workaround process through his Chief of Staff. And if in the media, Minister Sajan is already dancing around the issue, then it behooves us as a committee to have Mr. Young here and to give his side of the story. So I would just argue that any attempts to delete Mr. Young from this, I would say, I don't want to ascribe motive to my colleague, but I would look to her to seek to amend her motion again to include Mr. Young, and any concerns otherwise, I would say, are trying to perhaps gloss over or perhaps brush the involvement of Mr. Young under the rug, given that there's several media articles, including the one that I cited for the Globe, wherein Mr. Sajan has already danced around the press on what he knew when. And I just want to get to the bottom of this so that this doesn't happen again. And it's so that we're looking at major humanitarian crises around the world right now. We need to make sure that this doesn't happen again right now so that other people aren't impacted by that. So I wish she had separated the motion out, her sub-amendment. I can't support it without having Mr. Young here. I think what will happen without that is that we'll have these ministers maybe come, maybe not, and dance around the issue. I'm sure Senator McPhedran will come, though. That'll be interesting. But not having Mr. Young here actually materially changes the committee's ability to investigate this matter, and I would ask her to consider that.
Well, thank you very much, Madam Chair. Since the comments from my colleague was put to me directly, I'm happy to offer my thoughts with respect to that. First off, I want to be very clear to say that I'm not here to try and protect anyone or sweep anything under the rug for anyone. Those who know me will definitely realize that that's not what I'm made of. And so that as an aside, in this instance, in general, I'll say this. It is my view that electeds, and in this instance, when we're talking about government, ministers and former ministers needs to be held accountable, and they need to be open and transparent, and they need to take responsibility because that is their job. In the instance around the potential involvement of George Young, now I don't know the details of this case, to be honest with you, other than what I've read in the newspaper. And the matter is also under, as far as I know, unless if something has changed, under police investigation as well. Maybe that's concluded. I don't know. No one has informed me. Again, all I know is what I've read in the newspaper. So, but the first order of accountability rests with ministers and former ministers. They need to be held to account and explain to this committee and to the public in terms of what's transpired. Now, it may be, and we've seen it over and over again, that we can have ministers who come before us and they talk as though they've got marbles in their mouths and nothing comes out. And it may be that we need to sort of move into another direction to find the truth. And if that's necessary, I'm willing to absolutely entertain that. But we don't know at this point what will happen. And maybe I should know better, but I'd like to give that opportunity to these former ministers to come before this committee to answer the questions of committee members. If they refuse to come, per what we have dealt with before in the case of current ministers on the Afghanistan situation, for example, the Minister of D&D, the Minister of Foreign Affairs, Global Affairs, etc., we have moved the motion, passed the motion for them to come by a certain date, and then if that did not happen, then we would seek another means to trying to summon them then to come. And that, I think, that option is still available to us. If we invite these ministers to come by this date, which, if amended successfully, would be April 30th, and if they don't come by then, I would absolutely be happy to come back to entertain, to say, look, they are refusing to cooperate and we need to escalate up, and I would absolutely be happy to entertain that. If after these ministers come and they offer nothing, if, for example, important questions were put to them and the answers is, I don't know, I can't remember, the dog ate my breakfast kind of thing, and the dog ate my paper as well and my homework and all the rest of it, then I think, it warrants further consideration of what other action needs to be taken to get at the truth. And I'm open to all of that. But following the steps and procedures to which is before us, I think at this stage, I think we should move forward as I have supplemented the item. I want to turn and take a moment to talk about Dr. Lauren Oakes. And now, I had the opportunity to speak with Dr. Lauren Oakes after this motion was first moved. And
Ms. Kwan, if I can interrupt you for a second, just want to let the official, because I see a speaking list, so I don't think so there will be an opportunity to go back to S245 right now. After Ms. Kwan, I have the two other members who would like to speak, so I would really, on behalf of the members of the committee, thank you for coming today, and I'm really sorry that we have not been able to utilize your time well, and we had to get into the discussion of another motion. So if you want to leave, you can proceed. So thanks once again on behalf of all the members for taking out the time and appearing before the committee on an important legislation. So we'll just give a second for them to leave, and then...
maybe, Madam Chair, if I can just jump in before the officials leave. Given that, we're a bit pressed for time on this issue, and because committee members did not get through all the rounds in terms of questions,
they are leaving now, because we are on that, so we will proceed with the discussion.
Can I finish, Madam Chair, on the point of order?
Yes, Ms. Kwan.
And so, given that this motion has interrupted our proceedings. Given that S245 is going to be a bill that we will need to deal with in a timely fashion because it has to go before the House, and committee members did not get a chance to ask their round of questions, can we have committee's support to say that committee members can submit written questions to the officials so that we can get that those responses back for our consideration as we move forward on this bill?
Okay. The officials always try, like whenever we have requested, to answer the questions by the committee. So if members would like to proceed that way, they can send the questions to the clerk of the committee, and that's will be. Okay. Thank you once again. So, thank you. Yes, Ms. Kwan, you had the floor. You can please continue.
Thank you, Madam Chair, and I appreciate that to ensure that committee members would be able to send in written questions related to S245 for officials. So back to Dr. Lauren Oakes. So I've had an opportunity to speak with her after the motion was moved, and she expressed her concerns with respect to that. That as an aside, it may well be, as much as I appreciate the media and their reporting, but there may be times too where things that are reported by the media may not necessarily be 100% accurate. And there might be nuanced information that might not be captured in the article. And so to that end, I think it would be important, given that Dr. Lauren Oakes was referred to in the newspaper, that she be given the opportunity to provide a written submission to us. And of course, as always, committee members can always consider, at a later time if they want to invite people back if it was deemed that the information provided is deficient and further work needs to be done. And in which case, if that's the case, we can all take that into consideration. So I'll leave it at that, Madam Chair, and thank you.
I have two other people on the speaking list, but before we go to Mr. Dhaliwal, just want to ask the members, because in the beginning we decided to go for 5 minutes in camera to discuss what Mr. Brunel Desap would like to do that. The committee will end at 5:38. We started the meeting at 3:38. So, members would like to go in camera or proceed with this discussion now? No. So no. Okay. So we will proceed with this. Mr. Dhaliwal, you are on the next on the speaking list. If members don't decide, if there is no agreement, naturally we will not. Mr. Dhaliwal, you are on the speaking list, and then next is Mr. Brunel Desap.
Madam Chair, I certainly understand your intentions that it's decided by the members, but when Mr. Brunel Desap brought this forward, he needs few minutes in camera. That is also a very important work that we are doing on particular that issue.
If I can request, please, all the members to keep silence. One member has the floor. He is speaking. With side conversations, it's difficult for me to hear what the member is saying. So I would request all the members to please avoid side conversations. Mr. Dhaliwal.
No, not yet. Madam Chair, I'm putting my earpiece on. Thank you, Madam Chair. Madam Chair, we are doing great work. The motion that Madam Rampel-Garner brought forward, and then Mr. Redikoff brought the amendments, and of course, Madam Kwan brought the sub-amendments. That's a very important work, and we should continue to work on that. But at the same time, Mr. Brunel has brought in a request which is also important, and at times, we should listen to what he has to say on that particular issue. If we want to go into camera to have this meeting, discuss that issue that is important and near and dear to him and Quebec and Quebecers, I would love to support him on that one.
Thank you. Mr. Brunel Desaep is on next on the speaking list. Mr. Brunel Desaep.
Merci, Madame la Présidente. Bon,
Thank you, Madam Chair. All right, so people have a number of different opinions about a number of different motions, as well as on how to use our procedure. What I would like to know is, and what I'd like to deal with, is what went on last week. I think that it was a serious matter, and I think that those here present would prefer that we move to in-camera proceedings to discuss the matter. Of course, we could discuss this in public, but I think that some people would appreciate our working in camera. Now, about the debate now underway, I would be ready to suggest that we adjourn the debate for now, that this is a long-term topic, of course, and we could go back to what we brought up at the very beginning of the meeting, to the effect that we could go in camera to discuss what we wish to discuss. I did put this matter to the committee at the very beginning of our meeting, so I would adjourn Ms. Rempel-Parner's proposed debate for the moment and move in camera. That's what I suggest, but of course, the committee must decide, and I already have an idea of how I will vote on the current motion.
Mr. Brunel Desaep has moved to adjourn the debate on the motion. So, Mr. Brunel Desaep.
c'est différent.
Well, it's not exactly adjourning the motion on the debate. It's rather a matter that of this being filibustering. I'd like to go back to what we discussed at the outset. This is a dilatory motion. I would like to go back to what was proposed at the very outset. Then we can get back to this in due time. But it's nearly, indeed, 5:30. We'll never have time to address the issue. So right now, what I understand, Chair, is that we will be able to work until 5:38. It will take time to move in camera. There won't be any time left to discuss the matter I wish to bring up. So that's very unfortunate, but this is the way things go in committee. And next time, of course, what I will do is not ask to wait until the end, but not at all. I will ask to be heard at the very beginning of committee meetings, because I have the impression that I've been ill dealt with. Thank you, Madam Chair.
Lalonde.
Well, I tend to agree with my colleague. I think that we all had good intentions when we first came in to listen to the officials and their technical briefing, given how complex Bill S-245 is. I also thought we would be able to reach an agreement in this committee to the effect that we were working on substantive matters. I thought that's what we had agreed. So I was unaware of what the Conservatives would be doing to shift the nature of our meeting, given that we had a decision earlier. And I would really like to say I'm very sorry about this, because I would never have said we should push this off to the end. I think that, as you have said, Mr. Brunel Desaep, we should have dealt with the matter you brought up at the very beginning. Unfortunately, the Conservatives have once again shifted our work mode here in the committee. So back to the motion put forward by my colleague, Ms. Rempel-Garner, the amendment and the sub-amendment as well. Well, I believe that my colleague, Ms. Kwan, is bringing up some very good points, Madam Chair, some truly good points. There are hesitations, that's what we're hearing, and these are well-justified hesitations about, the possibility of doing such and such, or perhaps not. We do want to hear these people and see these people. That's why it's important to hear ministers, the ministers indeed who will be coming in, or having them come and speak to prior motions. And I was very proud, just before our break of last week, the government made an announcement, a very important announcement, about humanitarian assistance, humanitarian aid to people who need that help in Afghanistan. We know how important that is to do, and I was so proud to be involved in that announcement as Parliamentary Secretary. It was just wonderful to hear the Red Cross, an agency which may well
like avoid side conversations. It becomes to hear what the member is saying. Sorry, Ms. Lalonde, please go ahead.
Aucun problème, ça continue.
No issue. It's really a matter of our being polite with each other here in this committee. But as I was saying, the announcement was, it touched my heart. And some of us, when this announcement was made, really took to heart the effect, effect on humanitarian work of this announcement that will allow the government, based on an exemption, fully respectful of the law, the criminal code, to really help people who truly need our help. And I was referring, Madam Chair, to the Red Cross, and representatives of the Red Cross were present there, and they really were very clear with their support. Many applauded this. We were many to be applauding this. So I want to congratulate all of us on having carried out this work. It wasn't easy to accomplish this, but we managed to carry it through. It's something that has involved many departments of government, justice, public safety, and international development. Citizens and immigration as well. Many then undertaking to create this new approach. So I'm very proud to see that my colleagues' motions do bear fruit. It's quite clear that the government, and indeed we all agree how important it is to move in real ways, to carry out real work. This is something the government is able to do quite clearly based on all the accomplishments that I've just underscored. That said, Madam Chair, I will allow myself to say that we may perhaps be able to move to a vote. I know that we have a few minutes before we're 38 minutes past the hour, and I'm certainly ready to support sub-amendment put forward by my colleague, Ms. Kwan.
Mr. Dhaliwal.
Thank you, Madam Chair. Madam Chair, I just want to commend my dear friend Brunel de Sepp for being so patient. And next time, I agree with you, with him actually, Madam Chair, that when he brings his issue, and it should be dealt right way. And now we can see. But on the other hand, I support Madam Kwan's sub-amendment. I would love to see going to the vote and adjourn the debate, and let me adjourn the debate and vote on Madam Kwan's sub-amendment.
No other person raising their hands for the debate, so we will go into the vote of the sub-amendments by Ms. Kwan. So the amendment proposed by Ms. Kwan, Madam Clerk, if you can please take the vote.
Mr. Ali.
Ali. Yes. Go.
Mr. Dhaliwal.
Yes.
Sorry.
Sorry.
No, she said Mr. Dhaliwal. Then she will come back to you.
Mr. Ali.
Yes.
Mr. Dhaliwal.
Yes.
Mr. El Khoury.
Oui.
Ms. Kayabaga. Pour. Madame Lalonde.
Pour.
Mr. Kimmich.
Against.
Mr. McGuire.
No.
Mr. Redekop.
No.
Ms. Rempel-Garner.
No.
Monsieur Brunel de Sepp.
Oui.
Ms. Kwan.
Yes.
So the amendment moved by Ms. Kwan is adopted. Now we are back on the sub-amendment, back on the amendment proposed as by moved by Mr. Redekop. as amended. Yes, so we are back on as amended to Mr. Reddy-Cobb's amendment. So is everyone in agreement? Is everyone in agreement of the dates? Okay, so adopted. So the dates are changed to April 30th. So we are now back to the motion as amended. Yeah, do we have to vote on the motion as amended, Madam Clerk? Yes. So we are on the main motion moved by Ms. Rampel-Garner as amended. Is everyone in agreement, or we need to take a vote on that? Everyone is in agreement of the motion moved by Ms. Rampel-Garner and as amended? As amended. Yes. Okay. All those in favor? Okay. Adopted. So with that, we are exactly at 5:38. So do I have the will of the members to adjourn the meeting? Okay. Meeting is adjourned.